Right. Hi, Peter, again. Thank you for coming back for more punishment and more great information that you're going to deliver. So if we start at the beginning, please. Okay. What other information do you need, starting off when the sale starts, please?
The first thing we do as lawyers is we need to gather a lot of information from our clients. We need this information so that buyers don't ask us lots of questions or the same thing over and over again. So in order to achieve that, what we do is we send out paperwork to our clients. First of which, it will be an instruction letter. This is what we're going to do, and we have to make sure that this is signed and agreed and so forth. Otherwise, we're doing nothing. The next thing we do is we send out standard forms that need to be completed and returned to us. Now, in the past, a lot of people had looked at these and sort of said, well, look, how important are these forms? And this was true up until very recently, when there was a major case where someone actually lied on one of those forms about Japanese knotweed. And the case went on for 5 or 6 years. And in the end, it cost the seller £200,000. And what this has done is this has really focused people's minds in that these forms can be relied upon, and they can be really expensive if they're not done properly. So we need to get that along with ID and all this information from our clients. And we will need to get that before we do anything.
Okay, lovely. So I think they're called protocol forms. What exactly are these forms that need to be filled in, please?
Sure. They're called protocol forms because they conform to what the Law Society set out. So the Law Society said, we're going to have a protocol, in other words, the way of doing things, and these are the forms that you need to fill out. And there are 3 main ones. Now, the one that people always talk about is the property information form. It's quite big, it's quite tedious, and that tells all information about the property itself. Things like, for example, whether you had any arguments with the neighbor, or if you've got Japanese knotweed on your land and so forth. So everything about the property itself, what fences do you own, things like that. The second one is the fittings and contents form. And in that, people have to include what they're going to actually sell with the property, what they're going to give away, or what they're going to take. And these are really important because this forms part of the contract. And the way to think about it is if you look at, for example, the contents of a kitchen, you might want to keep the fridge, but maybe take the Aga. You might want to take the cupboards, but leave the curtains. So this form has to be filled in, and it's part of the contract. And the final one is the leasehold information form. And that asks the leaseholder, if they've got a flat, for example, all details about the property itself, who the managing agent is, who the landlords are, any things that you know about, any problems with the property and so forth, contact information mainly. And those are the 3 main forms that we have to give out.
Okay, lovely. So thank you. But what are the potential problems if they're not filled out, and how can agents help resolve those and contribute, please?
One of the biggest problems that we see is lawyers typically send these out by post. So obviously that's very slow. You might find it, they'll email them out. So then people need to print them and complete them. Sometimes, and it is an increasing trend now, people can do these online, which is really good news. The problem with it is fundamentally people don't like filling in forms. So as agents, we see a huge opportunity for you to help your sellers complete these forms. And you must remind them that until you've completed the forms, your lawyer's not going to be doing anything. So one of the biggest problems we get here is delay. And you can see this easily taking 2 or 3 weeks. And bear in mind that until the lawyer doesn't get all those forms, they're not doing anything. So as agents, get involved, ask your clients, have you sent back the paperwork? Crack on, sit down with them, help them out if needs be. We see more and more agents getting much more involved at the start of the process because this can easily add 2 to 3 weeks to the whole transaction.
Okay, excellent. You mentioned a contract. So what's in a contract pack, please, and when does it get sent out?
Absolutely. The contract pack is the start of the process when it actually sort of kicks off. And one thing to remember about conveyancing and the whole sales progression process is think of it as a roller coaster, and not a particularly nice one at that. Okay, but you get ups and you get downs, you get busy times, you get quiet times. And in the beginning, it's all with the seller. So what the seller needs to do is the lawyer, of course, the seller's lawyer, excuse me, they need to send out all of this information to the buyer. And that's what goes in what's called a draft contract pack. The contents of which, the main elements of these are the title documents, the contract, which are pretty standard. If you're selling a leasehold property, you need a copy of the lease, and of course the management pack. And all of that information is sent sadly, too often by post to the buyer's lawyer, who will then rely on it to raise inquiries.
Okay, so you mentioned title. What actually is title and what does it mean, please?
The title is the proof that someone who is selling the property actually owns it. The easiest way to think about it is think about it in two parts. Okay, you've got the title register and you've got the title plan. The register is the information about the person who owns the property, their name, their address, when they bought it. It also covers details such as who the managing agent.
Start again.
Start again. Sorry.
What's the title plan? What's the title? Start again. Okay. What's the title, please?
The title is a set of documents that explains and gives evidence to who actually owns the property and what is the property itself. So the easiest way to think about it is to split it into two parts. You've got the register, which has all the details of all of the owners of the property. It also includes information, for example, whether there's a mortgage on the property or any other charges. So it's really important, because what you have to do when you're selling a property, you have to make sure you remove all that. The other part of the title is something called a plan, and I'm sure most of you have already seen these. What these are is a plan of the area, and the title itself is edged in red. And that is used by the buyer to be used as evidence and source of evidence in order for them to carry out searches and to check that the actual plan of the property is what they think it is. And it's really important because they will rely on it.
Okay, so again, I think you summed up there what the potential problems are and how agents can contribute, but anything else to add to that?
There are problems with titles. A lot of people think quite often, oh, I can just get the title and it's going to reflect the current position. What are the most common problems? One of the most common issues that come up is the people that are selling the property don't actually own it. Oh, yes, I own this with my partner, or in that. Quite often we'll find it's owned in a company name, for example. More and more agents we're seeing are actually pulling details of the titles in advance to make sure it's okay. Because if there's a problem with it, it does need to be fixed. And so we would always encourage, especially things like plans. Typically, you see problems with plans where they think they have a parking space outside of their house, and suddenly it's just not on there at all. And then it all gets very heated. So make sure what the client actually thinks they're selling, they actually own. You see this particularly also with leases, and with leases there are plans that go with them, and which does form part of the title in effect. I think it's the easiest to think it that way, just to make sure that they do own what they think they own.
Okay, lovely, thank you. So you mentioned something called a management pack. What's in that, please?
A management pack raises its horrible head when you're selling a leasehold property. Before you can sell a property, you have to find out information about it in order to present this to the buyer, so there's no nasty shocks. Typically, things like, for example, if you own a flat and they're planning to renovate it, or they're going to put a new roof on it, but it's going to be in the future, but they know, for example, it's going to cost £50,000. Chances are there'll be a management company which actually collects the money to pay for that, and they will have to publish accounts and all information about that. If you're in something with a share of freehold, they would have to have carried out a fire risk assessment, for example. Now, all of this information is contained in a management information pack. We have to get these from the managing agent. They can be pretty expensive. We've had them going up to £700 or £800. And the main problem, however, is how long it takes for them to be obtained. You could easily see 3 or 4 weeks. And the problem with that, of course, is that the longer you leave that, the seller's lawyer has to send that management pack over to the buyer, and you could lose a lot of time. So we always say to clients, get it in advance. There's nothing stopping a client obtaining the management pack themselves. Problems you also find is they don't know who their management company is, so they don't know who to ask. So, so again, you can try and help out with that.
Okay, so that's a really, really great point there. So thank you. So management comes back, presumably then you've got something called sales inquiries. So what are sales inquiries and why or when are they raised, please?
Okay, this is the part where no one has a clue what is going on. And it's amusing. A lot of agents think, oh, they're in the dark about it. But I'll let you into a secret. Okay, lawyers don't know what's going on either. This is where we as sellers are sitting there waiting for the buyer to ask questions about the property. The questions they're going to ask is about the saleability or anything that might affect the value of the property. And it's really important as an agent to look at this and realize that probably you're not going to hear anything for 2 or 3 weeks. So if you want to help set your clients' expectations, say to them, you're probably not going to hear anything from your lawyer for a few weeks. Don't worry. This is the quiet period of the process. Then what will happen is you will then get asked a load of questions, and the clients will say, I don't know the answers to that. Okay. And this is a real challenge. And you're going to have to convince your clients that they do need to find the answers. And even though they're upset because they didn't ask those questions when they bought it, the world has changed, and chances are they're asked loads of questions that they won't know the answer to, but they need to find them, please.
Okay. So how do you overcome that when they can't find it and they come back to you and they say,
it's a really difficult problem. It all depends on it does depend on the buyer's lawyer. It depends what information we're trying to find. I mean, the classic one, for example, a gas safety inspection certificate. This is an absolute classic, or a fencer certificate. Now, ideally, you would prep your sellers to make sure that they've got all this information up front. But we know people can't find this information. You can get replacement certificates, or if in doubt, if you don't know where it is, get the boiler serviced and get that certificate created. That's most often the issues.
Okay, so any property that's got a boiler, basically the solicitor is going to ask for a gas safety certificate.
They are, it's one of those things. And even though it's buyer beware and so forth, as a seller, you've got to assume that the buyer's going to ask for this. So you obviously provide what information people ask, but for stuff as obvious as that, it's going to come up.
Okay, so is there any obvious things that sellers can prepare themselves with to gain safe time?
Absolutely. I mean, I gave some examples of things like certificates, warranties, guarantees, and so forth. Go through the files, take a bit of time to go through all the paperwork that you've got, inspections, you've had windows replaced, look for guarantees. These are the sorts of things that people are looking for, evidence that things have been serviced. Try and collect all that information that you've probably got somewhere, and do it in advance. It will save time because it will come up.
Okay, what will be great, without getting you to say yes right on the spot, is there a list that we can again give out and accompany this to people just to make it easier for them as to the sort of things they need?
Absolutely, and we can make these available. Yeah, we can put that to. It's a really good idea, actually, because a lot of people say, oh, we need information, but then actually say what they want. So no, that's a great idea. Absolutely, we can do that.
Okay, fantastic. God, there am I taking all your time and getting all this stuff, and you're doing amazing. So thank you. Right. So the next thing after the inquiries, and we always wished it was as smooth as this, is the exchange process. So how does the exchange process work for a seller? And again, what are the potential problems and how can agents help, please?
I think this is an area where agents really do bring value to the table. And what we would always say to an agent is get involved. I'm sure you've had loads of situations where the seller has been told, yes, we're ready to exchange. They may even tell you they're ready to exchange, but please do your checking. Before you can exchange, the seller needs to have signed their contract. They need also to sign the transfer that they would have received from the buyer. So if you want to make sure if someone's ready to exchange, make sure that they've got the paperwork signed and ready to go. Too many times we find a situation where the clients will say, yep, I've signed my contract, I'm good to go. If they haven't signed a transfer, it is very unlikely that it will exchange. Not impossible, but lawyers don't like it. So an agent, do your checking with the sellers. The other thing to be aware of is that as lawyers, we have to speak to our seller on the day of exchange. So again, as an agent, what you can do is say to your sellers, look, your lawyers will be calling you. You need to be available. Because we all know what's the first rule of when you sell a house. The first thing what a client does when they sell a house is they book a holiday. And the next thing you're trying to get hold of them and they can't. I'm going on a cruise for 2 weeks. You won't get hold of me. Okay. So please let them know. And if it doesn't exchange that day, they're going to call again in the morning. Okay. So they're going to have to get authority the next day. In terms of the process itself, it's actually quite straightforward. The two lawyers communicate over the telephone. They read through the contract to make sure that everything is correct. They check that the right fittings and contents form, in other words, the stuff that people want to sell or want to keep, is attached to it, and they set the completion date. That call literally takes about a minute. It's really quick. The problem is, of course, you can't get lawyers to get each other on the phone because they're always too busy.
Okay, so a couple of questions from that. is decision make. If there's two people on the contract, two sellers, they need both to have confirmation from both sellers or just one?
It's a really good question, because a lot of people think that if someone's married, then they're one legal person, and therefore you only need authority from husband or wife, or husband and husband, wife and wife, whatever, or obviously a civil partnership. You always have to speak to both parties. And you do need to get authority from both. I did hear a story the other day of a law firm that took authority and they didn't exchange for a week and exchanged anyway. That should never happen. It's got to be belt and braces. It's got to be both parties, and every time as well.
Okay. So you can sign on behalf of a client as the
Technically,
agent.
but we don't. In the good old days, before people started to sue you for everything, the problem is, and you won't find lawyers, with some exceptions, maybe in prime central London, you won't find lawyers sticking their neck out for their clients. Unfortunately, we certainly don't. We haven't done this for 10 years now. We used to be able to have authority to sign on their behalf. Unfortunately, that's no longer the case, and most lawyers won't do that anymore.
Okay. You also mentioned a transfer. So again, what is a transfer, please?
A transfer is a really important bit of paper, and it always amazes me that when people talk about electronic signatures and the risk of fraud and so forth, that you transact property by the signature on a bit of paper, and that's what it is. A transfer, or a TR1, you've probably seen these. These are documents that give all the details about the property, any special conditions in terms of transferring it from one person to another. The seller and all the sellers have to sign this document, and they need a witness. And that witness must be a non-family member, and it needs to be an original signature. So this can cause huge amounts of problems, because what should be a really straightforward situation where you sign, get someone to witness it, and then you return the paperwork to your lawyer, can often be extremely painful, especially if you've got people that are abroad. These need to be couriered back, and that can easily add a week. But we do see a lot of this, and then it's a really important document, and that's why you've got to make sure that it's correct.
Okay. And what happens between exchange and completion then?
From the seller's point of view, there's not an awful lot that we need to do, because what we're waiting for is we're waiting fundamentally for the money to come over from the buyer. Once we've received that money on the day of completion, although it can be sent earlier, but we're not really supposed to hold it for very long, and that's where it gets a bit tricky. We're only supposed to hold it for the maximum time that we're allowed, which for us is a couple of days maximum. And if it doesn't complete, then we have to send it back. Once we've got that money in our account, the deal is done. So don't be put off by lawyers who will say, "No, I need to give you authority," and this and the other. And we have all this all the time, believe me. There are some very unusual situations where this can arise, but the vast majority is once the money has hit our client account, then over to the agent to release the keys, and most importantly, make sure the clients actually leave their house.
Okay, lovely. So I think that's the majority of questions asked on the sale side. On a purchase, what does a lawyer need from their buyer?
The thing to think about with purchases, which is really important from the lawyer's point of view, is we are the gatekeepers to the money launderers. So what we have to make sure is that no one can buy a property without us knowing who they are and where their money's come from. So the first thing that we do is we ask for evidence of identification from our clients. Okay, that's a photo ID and something with an address on it. And this typically has to be less than 3 months old. This is where we hit a lot of problems with ID. So we need to get this information from the client before we'll do anything. The other thing we need to know is we need to know where the money has come from, because we talk about money laundering and so forth. And I've got one tip for everyone watching this, okay? And that's don't go to jail for anyone else. Really, really important that. So what we mean by that is if we've decided that actually there's something that we don't particularly like about that, there's a red flag about their ID, we'll need to flag it up. And during that time, we cannot communicate that with everyone, okay? So you may find it go quiet, and it's really important that we cannot allow anyone. If we do, and then the seller then gets wind that there's a problem, or the buyer gets wind that there's a problem and leave, then that's a criminal offence. That's called tipping off, and that's a jail time of 5 years and a fine just to make it worse. So really, really important on that. The other thing we need to do is not only see what bank account it's come from, By the way, most lawyers in the UK now want to have money in English bank accounts. They don't like them coming from abroad. It's really not a good thing. We insist on money coming from a bank account, and that's our regulators and our insurers that are asking that. The other thing is you need to know where it's come from. So, for example, we had someone right recently, a 28-year-old guy buying $500,000 cash. Obviously, this raised concerns. And we said, where does this money come from? And he said it was from the sale of Bitcoin. And at that point, I said, we're not going to handle this case. Not because I don't like Bitcoin or anything like that, but it's because our regulators have said to us, we're not sure about it, we're not happy about it, therefore you shouldn't do it. And it's a really important point that we do what our regulators and our insurers and the lenders ask. So before we do anything, we need that ID, we need to get all that information together. And the problem is, of course, is it can be really slow and really tedious, and we won't do anything until we've got that ID.
Okay, great. So thank you for that. And I think that's really, really important. And then just touching on that then, some of the buyers may have a gifted deposit. So what actually is a gifted deposit, and what problems can and does that present to you? And when's a good time of telling the lawyer about it?
Gifted deposits. As an agent, you'll know these are the bane of our lives. The reason why they're the bane of our lives is because no one tells us about it. We will have a client, an applicant, who will say, yes, I'm getting a mortgage, cash, don't worry about it, it's all fine. And they'll crack along. And then we get within a week of exchange, and suddenly £50,000 will appear mysteriously in our bank account. Okay. These are really problematic. And as agents, please, please get involved with this, because you really need to find out from the buyer if they are getting a gift, in other words, money that's not to be returned, from a parent, from a cousin or whoever, doesn't matter who. Okay, this is a gifted deposit, and we have to do exactly the same checks on their parents as we do with their clients. And the problem with that, of course, is that they get quite offended. So please, please, can you say to your applicants, look, your lawyer will be carrying out ID checks on your parents. Please warn them this is going to happen. It's nothing personal. It's just something that we need to do. But they are a huge source of delay and problems, and we find a lot of these. And as you know, most deals now involved the bank of mum and dad. So you will come across this all the time.
Okay, and just coming back, say there's two buyers buying a property in joint names. Presumably you have to do money laundering checks on both parties, or is it just one?
Wherever the money is coming from, we check everybody. And it's a really, really strict case, this. If someone is our client or they're giving money to our client, we have to check where that's come from, everybody.
Okay, so if two people are buying together, and maybe they're family members, maybe they're friends, would you advise having a declaration of trust?
Absolutely, 100%. What a declaration of trust is, a document. It's a legally binding document that says, in the event that you go your separate ways, this is how we divide the proceeds of sale of the property. Okay. And what our advice is always is get this signed before you get to the plate smashing stage, because once you're there, you're done. Okay. We see time and time again people who've bought property with brothers, with sisters, who they've had some argument, they've fallen out and no longer communicating, having huge problems selling properties without these. So we would always encourage, and even in some circumstances with married couples, we advise these. And what they are, and they can be quite complicated, okay, but what they are is they are a legally defined separation agreement, which says this is what this person will get, this is what that person will get, and it's a what proportion of the property and how it's distributed. And always, always we recommend, sadly, a lot of people don't take this up. It's going to be it's a tomorrow problem, and that's never a good idea, and because they never get around to it. It's a bit like a will. Yes, I'll do that at a later date, but I'm very excited, all of that stuff, and it generally ends in tears.
Okay, brilliant. Thank you. So after obviously that, and you get the paperwork back, you then apply for searches. Who pays for the searches, and what are searches, and when should the money be sent to a lawyer for searches?
Part of due diligence, really, from the agent's point of view, in terms of what on earth is going on, should be, have you lodged your money or put your lawyer in funds, to use the terminology they love to use? Have you given the lawyer money to buy these searches? Okay, it's far too often that we see people saying, "Oh, I must get around to doing that." Lawyers are really bad at checking onboarding, and they've got everything that they need. The buyer gives the money to the lawyer to buy the searches on his behalf, and it's really important to remember that the lawyer is buying them for that client. They belong to their client, okay? And that's really important because, say, for example, if it doesn't go through and you get another buyer that comes along, it's going to be up to the previous buyer whether they want to sell them or not. It's not up to the lawyer, and there's a lot of confusion about that. And interestingly, quite often we find that buyers don't want to sell their searches, even though they don't want them anymore. What are they? They are reports from various different places on any issues that might affect the value or the saleability of the property. So whether it's, for example, drainage and water, environmental, if you're in the south, HS2, but the one that everybody talks about is the local authority search. And this is the thing that is being blamed for all of the delays in conveyancing today. And I have to say, it's a load of nonsense. Local authority searches are coming back in 8 to 10 days. I had one the other day, came back in 2 days, which was a bit upsetting because we like to use it to buy a bit of time for ourselves.
Okay, so what would be in a local authority search, please?
The local authority search, the key to that, and it's really important to remember actually, that the local authority search just looks at the property itself. A lot of people say that, oh, it looks at the surrounding areas and so forth. It doesn't. What it's doing is it's looking at the particular property. Now, there are certain things that it's looking at, but the ones that affect us the most are planning permissions and building regulations. Easiest way to think about it, think of a house that's got an attic converted. And the planning permission is, are we allowed to convert that attic? Is this in line with what other people have done and so forth? And so a local search will show that it's been applied for and approved. Building regulations, the other side of the coin, once the work has been done, the building inspector will go out, check that it's done, check that it complied with what they said they were going to do, but also that it's safe. And that's called building regulation sign-off. Now, in the past, a lot of people sort of paid lip service to this, and it was quite often a case of, oh, we can insure against that. Well, that was always the case until, of course, the Grenfell fire. And that brought it into the public awareness, which was, if you don't have compliant building regulations or developments that are compliant, people can die from this. And it's really serious. And I think it sort of stopped people up a little bit short to say, actually, these are really important. And we've seen people take things a lot more seriously now. The challenge, of course, with Grenfell was that it was compliant at the time. It wasn't really appropriate. You know, flammable cladding is not a good idea. But what you've now got, obviously, is this horrible situation with 100,000 flats and properties around the country that people can't sell because of this issue. But it does need to be taken seriously. And that is why we carry out these searches in the first place, because we need to find out about these issues.
Okay, lovely. So you send off all the searches. Hopefully the buyer has put their lawyer in funds within the first week to save time, because that's what we're looking to do. Yeah. And then presumably the buyer solicitor will then start raising inquiries. So again, what are the sort of inquiries that tend to be raised, please, from that?
It's a really important point. Inquiries are obviously the buyer raises questions, and they can be about really 3 key areas. The first thing they're looking at is the title. Are there any problems? For example, will the charges be paid off? Is the person who said they were selling it actually the person themselves? So we're going to look at the title. We're going to look at, for example, if it's leasehold, we're going to look at the lease, make sure there aren't any problems with it. There is this common thought at the moment that with every leasehold sale, you get a free deed of variation, because really everything needs to be done with this at the moment. So we're looking at this and going, is the lease compliant? Do we have to change it for whatever reason? We look at things like the local authority searches. Is there anything there that we have any issues with? So the best way to deal with this is to raise the questions about all of the documentation that you've seen in one go. Raising questions piecemeal, people think it's a good idea, but it really isn't, because in the long term, you've got to raise all those questions. And what actually lawyers should be doing at the same time is they should be producing their report on title. What that means is, We raise questions, produce the report, and give that to our client at the same time. That's best practice. The problem with that is a lot of people say, oh, great, you've raised the inquiries and you've reported, therefore we're done. Unfortunately, that's not the case, because of course what happens is we send that report to the client goes, that's really interesting, if they read it, which to be fair, a lot don't. If they read our report, which, just so you're aware, freeholds takes about an hour, a leasehold can take about 4 or 5 hours at least. So there's quite lengthy reports. Then, of course, the client owes loads more questions. So you, as an agent, think, well, I've seen all those inquiries, they've all gone through, and suddenly you get a bunch more from the client. So be aware that the report is not the end of the journey, and actually can generate more inquiries as well.
Okay, brilliant. Thank you. So the lender. So why shouldn't the lender be ignored?
Don't ignore the lender. Do you remember that advertising campaign all those years ago about the FA Cup? Don't mug off the cup. Yeah, don't mug off the lender. It's so important. We have so many agents that say to us, we say, look, we've got a lender's requirements to satisfy. And you think, oh, that's a smokescreen. Really? Is it that important? Yes, it really is. We see one of the problems there is that we're acting both for the client and for the lender. And let's say, what is the lender worrying about? Am I able to sell this house? If this client defaults on his mortgages, can I sell the property? Okay, that's their number one concern. And so what we have to make sure is that we are complying with what all the lender requires. And that is a lot of work. And it also changes for every different lender. So that's really important, okay? And so what we have to make sure is that have we asked the right questions for the lender as well as our client? And they are really important. And the problem, of course, comes is if we find an issue and we have to go back to the lender, that can take a week, 2 weeks, 3 weeks, especially if they then have to refer it on. So please, 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 if there is a lender involved, it does have a massive impact on the deal.
Okay, so would you advise then buyers having mortgage brokers? Is it easier for a mortgage broker to get through to a lender, or is it easier for the buyer to get through for lender?
I think you know the answer to that question, Stephen.
There's people on here that may not.
We have so many clients that come to us and go, it's fantastic. I'm dealing directly with the bank, and I've got a much better rate, and it's so much more efficient because I'm doing it all myself. At that point, your heart sinks, okay? Because as you know, when you need to be able to speak to a lender, the brokers have access to people that no one else has, including ourselves, actually. And we will often rely on a broker to say, look, can you fix this, please? To speak to your business development manager. We don't have access to these people. And we would say to everybody, please use a broker. We don't do broking here. This isn't a plug. The point is that they will help solve problems. So if you, as an agent, have got a buyer that says, no, don't worry, I'm sorting out the lender, the mortgage myself. Please, please do whatever you can to encourage them to get a broker. Not only can they get better deals, but they can get the stuff through. So it's when we have a good broker on board, honestly, it makes a huge difference. Okay.
So what's the CML handbook?
It's a riveting read on a Sunday afternoon in case you've got nothing else to do. The Council of Mortgage Lenders Handbook, bless them. This is basically the rules by which the lawyer has to follow the requirements of the lender. It's all documented. If you are interested, it's all available online. And it's for every lawyer, every lender, excuse me, puts down their different requirements and what they will or won't lend on. So, for example, things like, like a flying freehold. If you imagine where you've got a flat that goes above another flat or encroaches over someone else's freehold and so forth. Some lenders will say, no, we're not going to lend on that. You know, the classic one, do we lend on flats above chip shops? No, we don't. That's all in the CML Lenders Handbook. The problem with it is it changes all the time. We get updates every day to the Lenders Handbook, and it's really challenging.
Okay, thank you. So we've done all the inquiries. And we're joined by the dogs now. Tell this is real. So, right. So how does exchange work for the buyer? Please.
From the buyer's point of view, as we mentioned earlier, we talked about the transfer. It's really important to be aware of who creates what documents. The buyers create the transfer, So where you get the problems with these, and we see this all the time, is the buyer has to fill in the name of the seller. And if they've got it wrong on the memo of sale, this is where you see it manifest itself. And it's a really common problem, okay? So the buyer will fill in the seller's name and quite often get it wrong. But so be aware that that can be an issue. We take those documents and we get our clients to sign them, witnessed by a non-family member, along with the contract. And then also we need to ask for a deposit from our client. Typically 10%, as you know, but it can be 5%, it can be £1. Now, obviously, if you're going to use a deposit and it needs to go up the chain, then it needs to be enough. And the purpose behind those deposits are there. It's got nothing to do with how much they're buying the property for. It's an arbitrary amount that says if you walk away for whatever reason, you will forfeit that 10%. And it's a mechanism to stop people walking away after exchange. So we need to have that deposit. So as agents, please, please, please let your applicants know that they need to transfer that money to their lawyer in good time, because we see too many delays of people putting deposits to their lawyers. And remind them that yes, they can do it online, but that's only maybe 10,000 or 20,000 a day. If you're buying a £500,000 property, that's going to take you a week to transfer that money. So get that money across to your lawyer as quick as possible.
Okay, thank you. And then what happens on completion, please?
On completion, it's more tricky on the purchase than it is on the sale, because what we have to do is we have to get the balance of any deposits from our clients sent over to us. We also have to get the money from the mortgage lender. And this is fraught with problems. You will have seen this time and time again where a completion is held up because someone forgot to order the money. Typically, we need to give notice of 5 days between exchange and completion, or to order the money, excuse me, in advance. So that's why typically you'll see exchange and completions for a week and so forth, because there's normally needed a week's notice. But you will see it where lawyers forget, and it does happen, they forget to order the money from the lender. Now, we always ask for it to be delivered on the day before. Lenders don't like it, but we always ask for that. And it's a good practice because it reduces that risk and hopefully gets that completion through. So once we've got all the money in our account, then we have to send that over. We have to check it, make sure it's correct, and send it over to the seller. And the idea is that contract time is typically 1 o'clock. So we really need to get them there before 1 o'clock. Now, there is an hour's grace that everyone pretty much gives, but if it goes beyond 2 o'clock, then it can be problematic. And that's when it starts getting a bit nasty. And if it fails altogether, that's where the buyer will then give up that deposit that they sent over on exchange. Okay,
lovely. So there's a few other questions I've got that have resulted from what you said today, if I can ask, if that's okay.
Of course.
So if I'm a buyer, should I be insuring the property between exchange and completion? And if it's leasehold, am I just insuring the contents, or am I insuring the building because maybe the freeholder has got insurance?
It's a really good point. Yeah, you are responsible as the buyer. It's a very good point, Stephen, actually, because a lot of people aren't aware of this. You do have responsibility from exchange. So you should, and the way to think about it, you should have insurance. The way to think about it, just supposing it burnt down, what are you going to do with that? And it sounds really obvious, but a lot of people don't know it. So warn your buyers that they will need to buy an insurance policy. Quite often they'll come to us, and there is a bit of a conflict there. Okay, so we can't really do that. Okay, some lawyers will, but they shouldn't really do it. Okay, they'll need to organize it. So say to your buyers, yes, you need to take on insurance.
And is that even if it's a leasehold property and okay. Even though the freeholder will have building insurance?
Well, you need to check that there is there. That's the thing. Okay, let's look at it that way. Let's make sure there is buildings insurance with that, because you don't. A lot of people assume that everything's in apple pie order, and so often it's not the case. Of course, they've got building insurance. Have they? So if not, at the minimum, check that there is insurance on there, and that's what your lawyers will do. Yeah.
Okay, lovely. There's another search, I think, called a chancel tax, which I know what it is, but I'm sure there's people out there who haven't got a clue what chancel tax is. Or in fact, when I do my little quizzes, what's that look?
It's, how do I put this politely? It's something that we buy because we should. It's based on a medieval law whereby if you lived within a parish where there was a chancel within a church, and not all churches have chancels, okay, there was a rule that said the Church of England could charge all parishioners a fee for maintaining that chancel. Okay, medieval law. Now, there's actually been two, but it was set off by one case where someone had a chancel in their garden, and this was put in place, and they fought it, and they said, no, we don't want to pay this fee to the local church. And the legal fees were hundreds of thousands of pounds. So, of course, everyone went, oh, wow, we need to insure against that. And millions of pounds have been spent on insurance over the decades, all right, for one case. And this remote risk, okay, is actually gone away now, sort of. The Church of England ran out of time years ago in order to make claims, but then they extended it and so forth. So, yes, we're still buying chancel insurance all these years later. It's only about £20, but every single purchase we buy this. And it's, yeah, well, it's a great money spinner.
Okay, great. I think a couple of final other questions. So there may be people that are watching that are buying for the first time. And you mentioned, flying freehold, you mentioned leasehold, you mentioned freehold, and you mentioned share of freehold. Yeah. And I don't know whether common hold is a thing yet or not. Can you just go into very brief details? So if we start with the freehold, what's freehold, please?
Yeah. First off, freehold. Think of freehold as a house. Okay, that's the easiest way to think about it. It's the property that is sitting on the land, and it's always about land. Okay, and it's really important. It's not the actual property itself; it's the land that it sits upon. Okay, so in other words, the easiest way to think about it is that patch of ground on which that property sits is owned by the person that owns that property. That's the freehold.
Okay, lovely. Leasehold?
Leasehold, again, typically flats. A leasehold is where you are part of a property which has got a freehold. So think of a house divided into three, and you are just responsible for that particular flat itself. There may be common areas like the hallway or the stairs and things like that that you share with everybody else. But the leasehold means you just own a part of that property.
Okay, lovely. Share of freehold, please.
Share of freehold, again, an area where there's a lot of confusion. People will buy it and thinking they've got a freehold flat. Now, there are freehold flats, but there's probably half a dozen in the whole country. It's very unusual. What it means is you're still leasehold, and it's really important. You've still got a lease, but you also own a share of the freehold with all the other people in the property. But the property is still leasehold. It's leasehold with a share of freehold. You cannot own a freehold of a flat that's part of another property.
Okay, thank you. I think flying freehold you described, but one more time.
Yeah, it's a flying freehold. It's a bit of a nuisance. The way to think about it, it's where a bit of a property goes over another property. It might be, for example, if you think of a terrace with a passageway that's got a bedroom over the top of it, or you see it where the other properties are being converted and a flat goes over the top of another property, and that's called a flying freehold. Interestingly, there's also something called a creeping freehold, and that's one that goes underneath another property. They're not so common, though.
Okay, there you go. I've learned something new today. I've never heard of a creeping freehold.
They sound a bit weird, but yeah.
Okay, lovely. Lease extensions. So you're selling a property, and it's 82 years. Yeah. The seller's been there for over 2 years. My understanding is that you can assign the lease over, so they don't have to wait. But why is 80 years important when it comes to leases?
Yes, it's actually increasing. Traditionally, it was always about 80 years. The rationale is it's 50 years plus the average length of a mortgage. Again, it's our friend the mortgage lenders that are interested in that, because if you look at it practically, 80-year lease, well, are you going to be living there for 80 years? Of course you are. Is that a problem? But the lenders don't like it because it affects the value of it. So if you've got a leasehold property that's dropping towards that 80-year mark, then you potentially got a problem. What you need to do is you need to extend it back up to a full amount. Now, we have seen lenders that have been demanding 99 years. So it is going up. And it's a bit annoying. What they're saying is the value is decreasing and so forth, but quite often doing that, you will typically see it go to 125 years. So you extend it to 125. But more commonly, especially with new builds, you're seeing these as 999-year leases, which are much better because it gets rid of that problem. The lease extension process is painful. As you mentioned, Stephen, one of the easiest things that you can do, if you want to assign it, and what you're doing is you're assigning the benefit of it. So what the seller can do is they can say, right, it's 82 years, but hey, here's an agreement, and it's an informal agreement. In other words, we're just going to have a nice discussion with the freeholder, and you can then send it over to the buyer and say, right, you can now extend it. And it's always the buyer that will extend the lease. It's not the seller. We do have people saying, oh, should I extend my lease before you can sell it? It's like, well, you can, and it will save time, but it's painful. And informal is quicker. But if you go down the formal route, where you have to serve notices and it's more complicated, it's more expensive, you've got to get valuations, that can be quite time consuming. So if you do have a property with a lease that's around the 80-year mark, yes, you need to deal with it. And it does need to be sorted out, but it will be the buyer that will sort that out.
Okay, lovely. Any other questions that I should have asked that I haven't asked?
You didn't mention about what's going on with land registry, which frankly, we all need to be aware of.
Okay.
If you're selling new build properties or new leases or transfers of parts, be aware that these are typically taking over 2 years to register at land registry, which is horrendous, because what it means is you can't sell them again, you can't remortgage them. So it makes it a huge problem. And what you find is buyers, and we're getting this all the time now, is buyers will then start to complain and think something's gone wrong. But it's really important, and particularly with new builds, okay? And just be aware and maybe set expectations for buyers that not to worry, it's been put in, but we are now getting return dates of over 2 years for registration, and there's no end in sight. We don't see this improving in the short term.
Okay, brilliant. Incredibly grateful for all your time. Really useful information out there. As somebody who's been in the industry and doing it for 35 years, I've learned an awful amount from you. So thank you very much. And I know whether you're a buyer, whether you're a purchaser, whether you're an agent, maybe whether you're a mortgage broker and a conveyancer, you've taken stuff away from this that will help speed up the process. Which is, one of the most important things. It is a really stressful, I suppose, process trying to buy and sell a property. So there's loads of good tips to speed up the transactions, to take the stress out of it. So thank you very much, Peter. Appreciate all your time.
Absolute pleasure. Really enjoyed doing these.
Cheers.